Mr. Speaker, sir, let me at the outset state that we are all in favor of preventing non-citizens from acquiring immovable property by trying to bypass the provisions of the Non-Citizen Property Restriction Act 1975. But it is a matter of regret that such an important bill is being rushed through Parliament. I could not even trace any cabinet decision, at least publicized, where making reference to this bill. And I say that it is a matter of regret because the drafting of this bill could have been improved and many loopholes could have been plugged if government had cared to hold proper consultation with experts in the field. Now, we all know the main object is to prevent foundation whose founder is a non-citizen or whose beneficiaries are non-citizen from acquiring property without the approval of the Prime Minister. But I'm afraid, Mr. Speaker, sir, that the proposed amendments are simply not sufficient to prevent a non-citizen from abusing the system by using a foundation. Let me explain. When we drafted the trust bill in 2001, the possibility of a trust being used to acquire immovable property was very much at the back of our head and was thoroughly discussed. There were wide-ranging consultations with stakeholders, including public notaries. I know what I'm talking about because I was part of the team that drafted the Trust Act 2001. And as a result, we had included a whole Section 22 in the Trust Act, which deals with immovable property in Mauritius. We made sure that no trust having non-citizen beneficiaries, having non-citizen settlor could hold immovable property in Mauritius. But we also provided that no non-citizen could subsequently become a beneficiary of a trust who already holds immovable property. But unfortunately, and it's a matter of great regret, Mr. Speaker, sir, that today we don't have any provisions in the Foundation Act which correspond to Section 22 of the Trust Act. And the bill does not provide for any amendment in that respect. And I don't know why. In the Trust Act, in the Non-Citizen Property Restriction Act, for example, in the definition of property, there is a specific reference to trust, who has interest in immovable property, whether legal or beneficial. So a non-citizen cannot acquire interest in a trust. But we don't have a corresponding amendment being brought to the definition of the property today to cover interest in a foundation which has immovable property. Why? Simply because we didn't hold proper consultation. The bill also does not cover foundations set up for a purpose. We can have a situation, for example, Mr. Speaker, sir, where we have a Mauritian dummy founder who sets up a foundation for a purpose. The purpose could be to acquire immovable property in a designated area or even pagiometric. Then that purpose foundation takes a loan from the non-citizen. And the non-citizen has the economic rights in these immovable property and enjoys the property. Now, in this case, the founder is a Mauritian, so he's not a non-citizen. There is no beneficiaries, so this situation does not fall within the proposed amendment. Yet, when we drafted the Trust Act, we took care to include this situation. Section 7, subsection 2C of the Trust Act provided, and I quote, notwithstanding subsection 1, no transfer or disposal to a trust shall be valid in respect of immovable property where the trust is a non-charitable purpose trust. So you cannot today use a purpose trust to acquire immovable property, but you can for a foundation. Why? Again, because no consultation were held before this bill was rushed through Parliament. It's so easy to go around this act using special purposation. There's so many loopholes. Let me give you another example, Mr. Speaker, sir. The foundation is founded by a Mauritian dummy. There is no non-citizen beneficiaries. so it doesn't fall within the purview of this Act and the bill. The foundation takes a loan from a non-citizen. So the non-citizen gives him money, and the money is used to acquire property. And a charge is created in favor of the lender, the non-citizen lender. Now, the non-citizen will say to the founder, whenever you rent out this bungalow, this property, whatever rent you receive, you'll repay to me as interest. Even better, the non-citizen lender can tell the founder, I will stay in that property. And instead of paying you rent, whatever rent I have to pay you, that would be deemed to be interest that I was going to pay, that you have to pay me on the loan. And being given that there is a charge created in my favor as non-citizen, the foundation will not be able to sell the property without my consent. So it's a very simple, basic way of going around this bill. And we only needed a simple amendment to the definition of acquire, alienate, hold, or purchase. We only needed to delete the words does not include the burdening of a property with a mortgage and a charge. Yet we are amending this definition today, but we're not deleting the charge provision. So we're allowing this loophole to perpetuate. So already too many loopholes, Mr. Speaker, sir, in that bill. Now let's see how it will work in practice. How do we enforce the law in practice? How does a public notary drafting the title deed know if the foundation has a non-citizen beneficiary or ultimate beneficial owner? How do the authorities find out whether there is a non-citizen beneficiary? According to Section 28, subsection 4 of the Foundation Act, there is a registrar. There is a register which is kept by the Registrar of the Foundation, which is the same as the Registrar of Companies. But in that register, you don't include the name, the details, the contact details of beneficiaries and beneficial owners. You don't. Now, it is true that at the time that you set up a foundation, you need to notify the Registrar of Foundation who would be your beneficiaries. But there doesn't seem to be any provisions of the law requiring you to notify the registrar each time there's a new beneficial ownership, each time there's a new beneficiary, contrary to what is happening in Companies Act. So once you have set up a foundation, going forward, you can change your beneficiaries, you can appoint non-citizens, and the authorities would not know about it. And yet, one of the reasons, Mr. Speaker, sir, why, and I'll end on that, why we're still on the grey list, the grey list of Financial Action Task Force as a jurisdiction under increased monitoring, is precisely because of this. Indeed, in its report published in February 2021, just recently, the FATF makes the following observation with respect to Mauritius to justify our inclusion on that list, and I quote, Mauritius should continue to work on implementing its action plan to address its strategic deficiencies, including by, and that's the important point, ensuring the access to accurate, basic, and beneficial ownership information by competent authorities in a timely manner. Ensuring access to accurate, basic, and beneficial ownership information by competent authorities in a timely manner. So why are we not amending the Foundation Act to provide disclosures of beneficial ownership, to allow it to be inserted in a register, which public notaries can have access to, which the authorities have access to? And then, Mr. Speaker, sir, we are wondering why we're still on the grey list of the FATF, on the blacklist of the European Union, and now the blacklist of England, for good measure. I know, Mr. Speaker, sir, that we are dealing with a technical bill, but I will urge the Prime Minister to go back to the drawing board, hold consultation with experts in the field, with public notaries, with people who will get involved with non-citizens, who knows what those non-citizens are doing to circumvent the law, and then come back with an improved bill before this House. Thank you, Mr. Speaker.